making the technology are able to go forward, get their interest there. At this point, to all of the panel members, like just one question, or in a way 2 questions, as I see Biju would give us a different perspective. 2 questions, as what's the way forward in which we can effectively collaborate and compete, fairly compete?
Yeah, I would give an example of the community I represent, that is Open Invention Network. So where on the Linux platform, like when I use the word Linux platform, we are talking about 2,335 softwares and applications. The Android phone you are using is one of the Linux platform softwares. So around Linux, we have an arrangement where everybody who owns a Linux platform and who is part of the community pledges that they will not do patent aggression against the community members on the Linux platform. So in this manner, the community member also does the same pledge towards the company who joins the community. So there is an ecosystem built wherein which on the core technology you will not fight, but you will fight on the services. So the technology can evolve and develop. Everybody can use that Linux technology and grow. At the same time, compete on commercial terms on the services. So this is one, and we have been very effective and successful with, in the last 10 years, from the formation of this community, we have almost 1,800 plus companies from various verticals. You have, automobile sectors who are part of this community. You have, so anybody who is using Linux platform, and today in every walk of life, we use the IoT of things, the automobiles, the future automobiles, we are, the mobile phones. So in every walk of life, we are using, Linux in one way or the other. And so if we don't fight on the core technology, and no, we don't have to talk about injections, we don't have to talk about codes. We have a system where we collaborate on the technology, because each company, each entity would have an expertise in a certain technology, a core competence. And that core competence is provided to the community on a basis of a pledge that I will not do any patent aggression on using that technology against the community. And the community in return does the same pledge to this entity who has given to the community. And secondly, we also believe in a system where we amass patents which can be used by any of the community members free of cost, and they can commercially exploit these patents. And these patents are on various verticals, medical technology, biometrics. So everybody grows, and there is no fear of injunction. So that's the world which we think of.
Thanks, Biju. Any final comments from the other panel members?
No injunctions for SC President.
Of course, I agree with him. Not in general. In fact, it is not in the mood of the... Not in the interest of anyone to just left and right seek injunction. It is only in the case of unwilling licensee that injunctions are to be made available. Nobody wants to litigate. Why? It's very expensive affair, right? It has to be collaboration, and therefore Ericsson has already, and it's a very happy thing to share with you that with iBall, a company with Indian origin, has entered into a global patent licensing agreement. It's a pure collaboration. With Apple, they have signed up an agreement. Nobody wants to litigate. In fact, just to give you a statistics, that worldwide, out of the total granted patents, it's in millions, right? It's only 1.3% of the patents that goes to the court of law, and only 0.3% ever goes to the final stage of the trial. Because it's a very, very expensive affair. I think it's a win-win situation if people collaborate more, but if somebody doesn't want to collaborate, injunctions has to be made available. But on the open source, I might be completely naive in asking this question, but I have heard that in open source, we claim to be open, but it's actually not open. because even in its open source mode, the person who wants to use that code has to seek a permission because it is under the copyright protection. Secondly, once there is any further development or any derivative of that software that is made, one has to disclose your code, and along with that code, the code of the proprietary code also gets opened up. And in a recent case, an open source holder received millions of rupees in the damages just because of the violation. So is it really open?
So they were not part of the community. So on the other different note, what we intend to achieve from the Open Invention Network community is not on the copyright front. We have the object that the Linux platform should be protected from patent aggression, so not from copyright aggression. So what we do is that every company who joins the community takes a pledge. So I'm wrong, sorry if I was not clear on the previous occasion. Every company pledges if they have a Linux platform patent to the community. And if a company who joins the community doesn't have a Linux platform patent, still he enjoys the benefit of the pledge from other companies who have a Linux platform patent. So for example, today, I joined the community. I don't have any Linux platform patent. I'm just a startup which has been formed yesterday. I still enjoy the pledge of 1,800 plus companies to use without any fear of injunctions or court orders. So that is the benefit we are looking at. That is the object of this community.
I just want to, I'll complete in 30 seconds. I just want to place a fact in front of this audience. When it comes to SCP validity of standard essential patents, according to one of the reports, only 12% of the patents that are taken to the not adjudication bodies, like IPABs, only 12% of the standard essential patents were held valid, and an astonishing 82% of the standard essential patents were held invalid. Just for your consumption.
And just to add to what SK said, there is also a study. Only 17% of the patents which were asserted as standard essential patents were ultimately adjudged as standard essential patents by US courts. 17, not 70, 17%. So those are the figures. Just one point, and see, the discussion on standard essential patents can never happen in black and white. It can't be a binary discussion, because every implementer has a dog in this race, and every implementer is fighting for his, or every implementer or every stakeholder is fighting for his or her own interest. Let's be very clear about that. But the one thing that we have to be clear is, it's not possible for the implementers to say, no, injunctions are a strict no under any circumstances. That's not a blanket position. Similarly, it's not possible for the other side to say, no, we'll go for an ex parte injunction the moment we have the opportunity to do so. That can't be the case. The test of the threshold or the particular line which triggers the grant of an injunction is always an unwilling licensee. The disagreement is who is an unwilling licensee, what are the circumstances in which a certain entity can be granted an unwilling licensee. That is the question. And before we proceed this, because I'm not someone who's in the habit of commenting on ongoing matters, particularly when I'm handling them, I'll just make one point and I'll leave it at that. So since Huawei versus ZTE was mentioned, people should also read Ringo versus ZTE. I'm just done. Ringo versus ZTE clearly says, a prospective licensee shall not be branded an unwilling licensee merely because he has challenged the validity of the patent, because it is his right to do so. This is something that court has held right from in the US Supreme Court, Lear versus Atkins in 1969, so on and so forth. The decisions have consistently held that a prospective licensee is at liberty to challenge the validity of the patent and yet not lose his status as a willing licensee. Thank you.
Thanks. We certainly had an interesting discussion here, and particularly good amount of time spent in understanding what are the various issues related with SCP, licensing of it, and how do we enforce. Now at this point, the floor is open for questions.
Right? So in the US, you have people who buy standard essential patents, right, and assert them against implementers. So, you have this problem in the US. So when this comes to India, I think maybe opinions might change on injunctions, right? Because then you have people who really didn't contribute much to the standard. They're just out to buy standard essential patents and assert them. And at that point, I question whether the theory on, well, yes, we should have injunctions still applies, because you know, you have good companies like Ericsson who have definitely contributed to the standards, but definitely you know, 3G standards and things like this in the past. But then you have people who have not contributed to the standard at all, or are just buying things just to assert them. And in this case, I would, you know, proffer that in this case, how could you really justify injunctions in that case? Because in that case, the person really just does want money, right? They, one would argue everyone really just wants money too, obviously. But I mean, so that's really not a case I would see that one should say, yes, we should have, you know, injunctions and standard essential patents. I mean, does that change anyone's view then when this starts happening in India? Do you still say, well, no, you should have a right to injunction on standard essential patent, because the players aren't really the same then, are they? I guess is the question.
Can I have a shot at the question? Yes. The test in India, when it comes to grant of an injunction, has certain similarities to the test in the US, which is the question of product displacement. So regardless of you buying a standard essential patent portfolio, or regardless of you contributing to the standard essential portfolio, the question that the court will ask itself typically is this: do you have a product which is being displaced by the continued infringement of your patent by the defendant? That's point number one. Two, is your claim essentially for royalty, a license fee, or is it one where you want exclusion of that particular product? Let's compare these situations to a situation where the standard essential patentee is also an active player in the mobile handset market. He will have a better case for grant of an interim injunction as opposed to an entity which is absolutely not in the business of selling or vending mobile handsets. Because at the end of the day, the continued infringement also eats into his market share, so he'll be in a much better position. So to answer your specific question, under the Indian framework, at least in principle, assuming that tomorrow we have a surfeit of entities who buy these portfolios merely for the sake of asserting it, they will be no different from entities which are contributing to standards, because all that the test requires is this: do you suffer product displacement? Is your claim pecuniary in nature and therefore compensable by way of damages? As long as these two questions are addressed, the object of you buying a particular portfolio doesn't make much of a difference. Of course, it may add to the prejudice value that you're at best a patent troll who's interested in suing people left, right, and center and getting money out of them. That may certainly be a prejudice point. But on merit strictly, these two situations will not vary much in terms of their outcomes.
And I think you are specifically referring to patent trolls and patent companies which buy patents. So I think out of the 5 litigations we saw in the Delhi High Court in 2015, 2 companies which had already bought these patents from other companies. So we already have seen 2 of them in the Delhi High Court. So we have already seen those already in the country in the last year.
And the follow-up is, wouldn't a better solution, this is just me thinking here, would be that kind of having the ability to go to a neutral third party to solve the dispute, because it isn't really the issue of money, let's just be honest, right? And so if the cases take 10 years or so in India, instead of having an injunction, right, because maybe it plays well now, but when the bad actors come, they will come, then maybe it's not really a great idea anymore, right? Wouldn't the better solution to be have this neutral third party, and is there such a way to have this in India?
There are already provisions. The Indian judicial system has enough provision to facilitate an arbitration or mediation or conciliation for determination of FRAN term. So as I said earlier, that in case of an SEP, the court has to essentially test the willingness of the implementer. If the implementer is a willing licensee, courts should not go to injunct that implementer, but courts should facilitate the parties to reach an amicable terms of license. For that, the parties can join together to name an arbitrator, to a valuer, to a body of arbitrators, maybe panel of 3. The arbitrator may be a foreign national, he's a known technical person, he can be a retired judge, so on and so forth. So there are ample provision. So this the court can do itself, or the parties can agree themselves to choose and decide upon an arbitration, the duration, the mode of arbitration, everything. There is ample provision. This is part A. Part B, to your first query, if a patent troll company comes, then in India there is a settled law, there is a precedent on this. If a company has not worked its patent in India, then it may be entitled for damages upon a trial and the decision, but no injunctive relief should be granted to such a plaintiff. There is a precedent in India. There is a precedent, and that precedent has been relied upon recently and again in the cases where a plaintiff patentee has not worked or is not working its patent in India. So far that case law is there in India. There is a precedent in that regard.
Is that right? I mean, I guess I don't have enough facts. Ericsson produces phones in India, though? Or no, right?
I'll just clarify about, since you asked a question about Ericsson per se. This company has been in India for over a century, 100 years. And it's never the thing that the R&D happens somewhere else in some foreign country. R&D happens in this country, and it has been happening for ages now. And there is a manufacturing location, very much in Jaipur, and one more place, Pune, it is coming up. So as far as manufacturing is concerned, it is happening by the Ericsson. Is there something else that you want to ask more specifically?
About that, no. I was just going to have a final comment about logging this. I guess my final comment would be, I think there's a differing of opinion on holdup, right? Because some would say that the Microsoft Motorola case in the U.S. is a sign of holdup by the SEP holder, right? Because they requested $3 to say $4.50 per unit, but at the end of the day, what did they get? They got like, what, 0.03 cents. So in a sense, that is a holdup, I think some people would say. So that's just final comment.
I'll quickly just answer the question of arbitration.
Two more questions. Three more. Yeah, three hands. Yeah, fine. I see we are nearing.
So I have one comment and probably a question regarding the standard setting, participation category in the standard setting organization. So when you mentioned the category, it appeared that the second category of people are not really contributing the standards. They're just waiting and watching how things will go, and then start copying the technology and make a product out of it. So is it not like taking a free lunch and just, and then arguing against it? That's the first question. And the other comment regarding this DSDSI and participations of OEMs, I don't see any patents, any technology contribution coming out of these OEMs. I see them importing and just, selling the products. So are we not again saying that, you are not contributing technology, so why are you cribbing about it again for, free lunch? And third thing about the open source, the debate about whether Linux kind of a model is good or proprietary model is good is, I think, kind of over. Industry has already expressed that both of these are important. And if you look at the licensing agreement between Microsoft and Red Hat, which happened a few years ago, clearly shows the way that collaboration is the way to go about it. And, you can still have both the models. We have companies employing both proprietary and open source softwares and doing wonders with that. So both of them are necessary. I don't think that's a debate anymore. Thank you.
Yeah, regarding your question on free lunch, everybody cannot be a technology contributor, right? So in this party of standard settings organizations, there are technology contributors, there are technology implementers, and technology implementers are not supposed to go and implement it without getting a license from technology contributor. From that perspective, there is no free lunch, right? Standard implementers or technology implementers are supposed to pay reasonable royalties based on FRAND to technology contributors, so that part is taken care of. There are no free lunches. I just wanted to clarify that. And on TSDSI, yeah, please go.
See, and this is just to build on what SK has just said. I think that point is very validly made. Because at the end of the day, one, let's be very clear, nobody is advocating here for a free lunch for any particular party. The central issue is reasonableness, and how do you arrive at what is reasonable? Let's be very clear about that. And on that aspect, nobody differs. The only question is what is reasonable from whose point of view. Second, in terms of TSDSI, it surely can't be anybody's case that two people will sit and decide a policy which has a bearing on a third party without even seeking representation from the third party. Let's be very clear. At no point of time can it be anybody's case that the implementer's point of view is sacrosanct and there can't be any departure from it. No, it's not Bible speak. Let's be very clear about that. However, to say that you can have absolutely no say because you have not contributed to the standard, no, that's not the way to go about it. Because for one simple reason, this aspect of representation brings in the element of proportionality, which is a legitimate principle that is recognized even in the grant of punitive damages or damages in a case. The Supreme Court has consistently held that what a right holder is entitled to at the end of the day must be proportionate to his contribution, not in terms of technology, in terms of his claim itself. This principle of proportionality, I'm only applying it and superimposing it on the framework of standard essential patents. And from that point of view, to say that the right holder will be the last person and will be the only person when it comes to what is reasonable may not be right, because at the end of the day, you can't be the judge of your own case. That's my simple point.
Yeah. As regards to your question regarding the open source, I have not debated on that. My only point was how we can see from this example of this community that how a technology can be used by everybody in a mutually convenient, collaborative manner and can benefit everybody. So otherwise, the growth of technology would not happen. If one company does, in one domain, a superb work,